Okay, students, this lecture will set out learning units 3 and 4, which talk specifically to internet contracts and electronic commerce. My email and my details are there, just so that you guys can contact me if required. So we look at internet contracts, that's learning unit 3, and legal aspects of electronic commerce, and that is learning unit 4. This builds upon the background and basics that we talked about in learning unit 1 and 2. So what will we do here? We will discuss several aspects of contracts, which were one particular one was alluded to. For example, when does a contract come into being? Specific provisions that are enacted in the ECTA, rules of consensus, and so forth. Then, of course, formalities. When does a contract have to be written down? What are electronic commerce? What about those buttons that you press and they come into? What should you be able to do at the end of having engaged with the guidance provided here, as well as the very specific sections in the case folder, the articles, as well as extract for books. Remember, all of your material that you need to study is available on the My Module site. Very specific folders, please go look at them, and of course the legislation. So you should have everything at your fingertips. So we look at offer and acceptance. It becomes a very interesting thing. When does that happen? When you get that meeting of minds, when you have this very, very specific thing that is happening online through the zeros and ones that are sort of traveling at high speed. What is a click wrap and a shrink wrap agreement, and whether such an agreement will be valid. When and where an internet contract takes place. What about the formalities of writing and signature? The idea of electronic signatures, what qualifies as an appropriate signature, and of course, whether they can be amended. Reading materials, as I've alluded to already, there are very specific folders on the My Module site. You've got chapters in books, you've got the cases, you've got journal articles, and of course the legislation that applies. Please read everything thoroughly, deal with it, learn how to integrate it in your everyday. Now, there are certain legal uncertainties that come in when you use in the internet for contracts. And one of the main highlighted one, Iceland, is the validity of the agreement. Can a contract be validly concluded utilizing the internet? When do you have that meeting of mind? You've got the idea of an offer and acceptance, and you have to have that agreement on very basic things. Law of contract tells you you have to have an agreement, and you have to have consensus. Sometimes it will just be ads and advertising and things like that. So keep that in mind. And of course, where it takes place is quite an important thing as well. You have to, if you've got cross-border transactions happening, you've now clicked a certain number of buttons and all of that. When does this happen? Are you entering into a contract in South Africa or elsewhere? Those are very, very important things. I mean, the kind of law that will apply might change dramatically. Of course, what happens when you need a signature? What is a thing? What would a signature be, and what qualifies as a signature? Do you have to have an accredited signature that is done in terms of the act, or can it just be a signature, or just a little button that you press? Shrink wrap, of course, these are where you are buying a service like software. Here you basically just click things and you've agreed to things and you've entered into things. So those are very important things to remember. There you're entering into a fully online in e-commerce contract. which jurisdiction applies. And here, where a contract is being entered into becomes crucial in terms of, the jurisdiction of courts, which one would apply directly. When an international transaction has taken place, what governs the relationship? So what is it that you need for a basic principle of contract? What do you need? This is way back from your law of contract days. You need consensus, meeting of the minds. Of course, parties must have the capacity to act. You have to be 16 and older in South Africa, might be different elsewhere. You need to fill the requirements, and some contracts require them to be in writing. For example, when you're buying land, legality, it must be lawful, and here the jurisdiction may become quite important. You might have that in some jurisdictions you can buy dacha, for example, and in others you don't. You cannot, and it's illegal. Of course, that the obligation must be able to be possible, and there must be a certainty as to what that obligation is. So you have to have an offer and an acceptance. Brings you together, the meeting of the minds. And here the JAFTA case is incredibly important. You will read it. It's actually fairly a nice, lovely a case to read. It flows quite nicely and is quite interesting. It's to do with a labor contract. Excuse me. Where somebody was offered a job. They were unable to, even though they had agreed to communicate via email, they were unable to, and then they agreed later on to communicate in a different way, and the person accepted the offer. And when they got to the job, they were told, well, no, actually, you haven't. We don't think, you agreed to it. We had agreed on a certain use of of a type of medium. And the court actually said, well, hang on. Yes, you initially might have agreed on something, but since then you had agreed to communicate in a different way, and that was sufficient. And the person accepting the offer was enough. So offer is not, when somebody offers to say, well, I'm selling this product or a service for a certain amount, that's an offer. It's only when the other party to the contract actually accepts it that it becomes a contract. So just remember, it must be a firm offer, must be complete, and the offer must be clear and certain, and the acceptance must, of course, then accept that specific offer. So those are very important things, and the JAFTA case actually talks about it quite well. So just keep in mind how that played out in that case. We have the reception theory, the expedition theory. Section 22 of the ECTA, of course, then brings a third approach, which is it really looks at the reception theory and the time and place of when the offerer accepts the offer. Section 22 specifically says that an agreement is concluded between parties by means of an electronic communication when it's concluded, time and place where the acceptance was received. So it really thinks about the reception theory and sort of puts it right there. What about formalities? And formalities are really there to ascertain who the parties are. So it provides legal certainty, identification, which I think is one of the big issues when it comes to electronic commerce. You don't know who the other party is. You don't know enough about the other party or the product or the service, and you need to know who they are through some form of identification, attribution, and authentication. And so all of these are the kind of things that the formalities are trying to resolve. Section 12 talks to that it must be in writing, that is in a data message in an accessible, usable manner. Section 13 talks about an e-signature as something that is incorporated and logically associated with other data. And of course, very specifically, Section 37 to 38 talks about advanced electronic signatures, which are utilized for very specific purposes, and that is a whole other process. you don't need it for a normal everyday contract. Section 13, remember to differentiate between parties agreeing to have some form of, they have in the contract itself, they specifically require that, or and then where it is required by law. That's section 37 and 38. For that is that those are the ones where you actually require it by law. So those are the two very different situations. And here, like you to look at the two cases, Springfield and Global Local Investment Advisors. What about automated contracts though? So you've got all of these other contracts where you've got this meeting of minds happening and formalities and so forth. What about those automatic ones where you just click and then it's gone? And here, right at the onset of the ECT in section 1, sorry, they really talk about automated transaction and electronic agent, and section 20 talks to automated transactions. And these are where, there is actually an automative function that comes in where people aren't involved throughout. So just remember that. And of course, an electronic agent is a computer program or an electronic or automated means of making sure that, of course, the contract. What is a shrink wrap? You've got the definition right there. Please read it up. There's links here embedded in the PowerPoint itself. Click on those, find out what more there. But these are where goods, you are basically agreeing to specific terms and conditions, price of warranty and so forth. You sort of scroll down and you say, I've read it. In most instances, we end up not reading these things. We should though, we really should. A click wrap is also exactly there, where you've got the software licenses and you scroll and scroll and scroll. That shows the computer program. You're reading it, and you enter into effect. So just remember, there are specific sections of the ECTA coming in, and of course, legislation. What about the jurisdiction and applicable law? Remember here, the time and place of when the contract is entered into has a grave and very specific impact, and that is that if you enter into contract within the Republic of South Africa, that high courts would be the court that you would go to. However, with cross-border transactions and so forth, you might have either specific provisions in the contract, or depending on where the contract has been entered into, you might end up having agreed to jurisdiction of a different court. So just keep all of that in mind, that you need to really be able to assess where the contract is being entered into for this reason. If fraud happens in the contract, what would that mean? Keep in mind. And I'm going to stop there. So here, just remember, we're linking back to a lot of the things that you've done under contracts themselves, the law of contract that you've studied before. So there's that linkage. However, the ECTA comes in and changes things specifically, and please remember to be able to easily reference these things, read the cases, be specified where they are applicable, read the extracts with books as well as contracts. So I'm now going to move on to Learning Unit 4. And if you want to, you can pause after Learning Unit 1, go back, read all the things you have to again, and then move on to this and reading all the other things. So in this one, we are looking at the implication of e-commerce on specifically things like consumer protection. What about, direct marketing, unsolicited communication, spam? I mean, we do have various laws now trying to deal with it and control it, but you're still being impacted highly by these things. And this is something that we are not just dealing in South Africa, everywhere. This is a major issue. I don't think we'll be able to get away from it as easily as we think with just pieces of legislation. Again, the prescribed reading material is Iceland, Papadopoulos in cyber law, and then of course the case, the Kettler case, as well as the journal articles here. And here, we've got colleagues that we worked with until last year, and Dr. Cloudy, who really wrote about this, and it's fascinating to always see people that show up in your reading list, which is excellent, really. I think we'll refer to her again when we get to tax at the end of this term. So consumer protection, remember we've got a Consumer Protection Act of 2008 that was agreed, centered into law on 2009, came into effect in 2011. It's been the culmination of several decades of work. I mean, debate and development, and you've got the ombudsman there that comes in. All of, it's a whole setup, and I think they do excellent work. In addition to that, the Consumer Protection Act, you will also be referring to the ECTA, as well as Protection of Personal Information Act, or POPI as we know it. All of these things come together and try and create a net of legislation that tries to protect the rights of consumers and right against getting a lot of these things. So this CPA, the Consumer Protection Act, came in through the Green Paper, and this is just as a background to legislation. We start off with the Green Paper, then we have White Paper, and then we have a bill and an act. So this all goes through a certain process. So this has been a long time in coming. There's a great understanding that the internet, when it moved from the research to a more business and social type of medium, that we would have to try and protect consumers in addition to just what we were doing with other things. And it's to make sure that the consumers have a lot of confidence, because I do think, despite COVID-19 and the greater use of, I think, online services and goods and so forth, and people buying things, that we make sure that people don't get defrauded, and that people are protected, and it increases the confidence, and therefore people will utilize it more and more, and we'll move into a society that's very much online. And how do we do that? According to the Green Paper, what were the things that consumers needed to be protected from was firstly spam, unsolicited goods and communication, dangers from the convenience of buying online. You sometimes, some pictures look wonderful, you think you're getting X and you actually get Y. Accessible nature of websites, of course, there's an invasion of privacy, collecting data and so forth, and selling your data. And of course, sometimes you would just have insufficient information about their suppliers, and you can't go and check it and touch it and feel it and know what is happening. And of course, fraud that does happen. Some of these things that the consumer needed to be protected against are now part of the ECTA Chapter 7 and 8. So with consumer protection, ECTA, we look at a very specific parts, Chapter 8, that talks to cooling off. Sometimes it just looks really good and you say yes and you want to buy it and you agree to it, and then a day later you think, oh gosh, I can't believe I said yes to that. So there's a allowing consumers to have that cooling off period, unsolicited goods, and of course services. How can you unsubscribe from spam? This idea of, should they be an opt-in or an opt-out clause? And we've finally moved to an opt-in. So if you opt into getting spam, then you get it. You don't have to opt out of it, and so forth. So there's all sorts of things that come in. The case of Kettler is quite important. Please have a look at that in great details. And of course, we've referenced the extracts of books that. So what is the purpose of the Consumer Protection Act. And here that is set out clearly in Section 3, and that is really to make sure we've put in rules that make marketplace a fair place, accessible and efficient. Make sure that consumers are not being defrauded through deceptive, misleading, unfair conduct, to actually promote their confidence. Really, and just remember that all of these three acts in this specific instance work together to protect the consumer. Also, these are very specific things then that the CPA introduces. And in addition to the CPA, which has introduced quite a few things, we now have also the protection of personal information. And that's really to stop people from misusing or collecting information and then utilizing it, repackaging and selling it. And really, and because we have a right to privacy in our Constitution itself. From that point on, make sure that people don't monetize your information without your consent. And it establishes compulsory and voluntary measures, provides people with rights and remedies, and what can you do if somebody takes your information? And again, we set out the sections there so that you know what to reference in the Papaya Act. Remember, there's Professor Swala's article to read, but also look at the section specifically, and see what question is being asked. You'll need to know this. You'll need to reference. Remember, your exam is an open book exam, and we expect you to be able to reference things. Apologies, I have a bit of a cold today, so you are getting a very husky lecturer today. Apologies for that. And also, Papaya then also covers an additional thing, data subjects, where you have agreed to be part of some sort of an experiment, and what do you agree to? Can they then, once you've agreed to one, let's say giving information on one thing, for example, you agree that you are a Watercom subscriber, you say you agree to give them information about their service, and then they suddenly start asking you all sorts of other questions about your preferences in terms of smart products or whatever it is. They need to make sure that they've asked you to agree to that thing as well. So what you agree to becomes the thing you've agreed to, and anything in addition is exactly that. What about this wonderful thing that we all love to hate? Spam, direct marketing, where you get this call about your insurance or bank or whatever cover, and we still get those. And this is despite wonderful provisions that they've set out in ECTA and Papaya and so forth. So there is here, I think it's also important to always link up to what is happening elsewhere to make sure that we are regulating in a similar kind of way. Just remember that other countries are dealing with this as well. It's simply a sort of a problem that everybody has. So they define what it is, they define how and when you can talk to somebody, and of course the penalties. And here again, please refer to the article of Saleh's study to talk where they do a comparison. So in regionally, we have the African Union, COMESA, and SADC references to spam. It is something that people are bombarded with, and it becomes an issue. So please do look at these regional things as well to get an idea. Consumer protection, of course, also comes in to provide and to additionally provide for protection. Here, they talk about advertising and so forth, and how do you deal with it. So all of these talk to direct marketing and why and what it is that one can do to stop getting spam. And it is a very wide definition in Papaya's: text, voice, sound, or image done on electronic communications. So just remember that consent means any voluntary specific information. And in section 69 to 71, it's very, very detailed You'll need to know this section really well to talk to spam any question that is given to you about this. Know these sections very well, see the penalties, when can you do it, what are the penalties, harvesting of email addresses and contact details. Please be very. I'm going to stop there, and remember, these lectures are really to give you a guidance. You will still have to engage deeply with the extracts of books, with articles, with cases, as well as legislation and other regional materials. Please go read them. These are merely guidelines for you so that you can situate yourself. Thank you.